you want to cater for successions of beneficiaries out of your property or out of the income accruing from that property, you can adopt, the doctrine or the concept of settlement. So if you have a property and your intention is that you want, succession of beneficiaries to take from that property or from the income accruing from that property, a method that you can adopt to get it done is known as the concept of settlement. Now, it is a device by which a landowner will make provision. He will make provision out of his property or the income from such property for the purpose of fulfilling certain objectives. The objective could be that you want a succession of beneficiaries to take out of that property or income accruing from that property. So if I may repeat myself, or if I may have to recount what I've said, I'm saying that settlement in real property law relates to limiting land. You will limit land to specified persons in succession for their enjoyment by the landowner. Now, the landowner will limit that real property in land law to, specified persons in succession for their own enjoyment. So what I'm trying to say is that, settlement is a situation whereby property law, is a situation whereby the landowner will limit, will limit land to specified persons in succession for their enjoyment. And then how does he do that? He does that, or is able to do that when he desires to provide for a succession of beneficiaries out of his property or the income arising from that property, and then he goes about to do what they call, settlement. He goes about to do what they call settlement. So, like I mentioned, it's a device by which a landowner makes provision out of his property or, income from the property for the purpose of fulfilling certain objectives. Okay, the objective may be, to provide for interest in the property to two or more persons in succession, and to convert the property into money for the purpose of achieving the desired objective. So the whole essence of settlement is for the landowner to limit land to specified persons, in succession for their enjoyment, or more or less find a way to provide for the succession of beneficiaries out of his property, or the income accruing therefrom. And then the method he can make use is what we call settlement. Now, this arrangement known as settlement could be done, in either of the two ways. One of them is called strict settlement. The other one is called trust for sale. One of them is called strict settlement, and the other one is called trust for sale. The method that you are going to adopt will depend on the intention of the landowner and the object of the settlement and the requirements of the applicable law. The method that you will adopt, whether it is strict settlement or it is trust for sale, will depend on the intention of the landowner, as well as the object of the settlement and the requirements of the applicable law, depending on where you are situated in the country. Now, strict settlement, if we are to adopt strict settlement, these are the basic rules, in summary, basic rules that would apply or that will be applicable in summary. Now, the traditional conception of strict settlement, of course, before the Settled Land Act, please note very well, there is strict settlement in existence before the Settled Land Act of 1882. Now, the traditional concept was that the settled land should be kept in the family through successive generations. The settled land, the land that has been settled, will be kept in the family through successive generations. Now, the doctrine of estate was adapted. It was adapted to achieve this purpose. So what I'm trying to say is that they have adapted the doctrine of estate to achieve this purpose of strict settlement. The strict settlement is intended to do what? To make sure that the land is kept within the family through successive generation. So now the essence of strict settlement is to make sure that some people, successive beneficiaries, they benefit from that property or the income accruing from that property. So, like I mentioned to you, a method of creating settlement is what we refer to as strict settlement. And the second method, hello, can you people hear me? Can you hear me?
Yes, sir.
Okay. Second method is trust for sale. If somebody is talking, let's keep quiet. It's trust for sale. Somebody is talking. Trust for sale. So, and I said that traditional conception of strict settlement before the Settled Land Act was that the settled land, the land that is settled through, strict settlement, will be kept in the family through successive generation. And how was it possible for them to do this before the Settled Land Act? How was it possible for them to do it? They said that the doctrine of estate was adapted to achieve this purpose of a strict settlement, which was intended to keep the land within the family such that a successive generation or successive beneficiaries will benefit from the property or the income accruing from that property. Now, the way they have adapted doctrine of estate to suit this purpose is, for example, Ahmed will execute a deed of settlement. He will execute a deed of settlement, limiting the land to himself for life. It will limit the land to himself for life, and then to Ben, for life, and then to the first and every other son of Ben, successively entail. I'll repeat myself. I said that the traditional concept of strict settlement before the Settled Land Act of 1882 was that settled land should be kept within the family through successive generations. And that the doctrine of estate was adapted to achieve this purpose. How did they use doctrine of estate to achieve it? They said that an example could be that Ahmed may execute a deed of settlement, limiting the land to himself for life, and to Ben for life, and to the first and every other son of Ben successively entail. That's a good example of how they have adapted the doctrine of estate, how they have adapted the doctrine of estate to achieve strict settlement. Now, with a resettlement that is reflected in this generation, the land was held by a succession of limited owners, because resettlement in that example is reflected in each generation by that example that we have cited. Now, by that doctrine and that by adapting doctrine of estate to settle land, what we have in effect is that example that I provided for you, and it will lead to a resettlement in each generation. It will lead to what? Resettlement in each generation, such that the land was held by a succession of limited owners, none of whom could claim ownership, of the fee simple, with the fact that the land remained, practically inalienable. So whatever it is that you own by this method of creating an estate, it is going to be, it's going to be a limited ownership, and that what will happen is that it will be impracticable for you to alienate it. So what I'm trying to say in summary is that settlement in real property law relates to limiting land to specified persons in succession for their enjoyment by the landowner. Therefore, a landowner who desires to provide for a succession of beneficiaries out of his property or the income accruing from that property may adopt what we call settlement. Of course, it is a device by which the landowner makes provision out of his property or income from such property for the purpose of fulfilling certain objectives. These objectives may be, maybe to provide interest in the property to two or more persons in succession and to convert the property into money for the purpose of achieving the desired objective. Of course, this arrangement, like I mentioned to you, can be effected in either of two ways, namely strict settlement or trust for sale. The method to be adopted will depend on the intention of the landowners, the object of settlement, and as well as the requirements of the applicable laws. Now, when we come to strict settlement, and I said that the traditional conception of strict settlement before the enactment of a Settled Land Act of 1882 was that the settled land, the land that is settled, should be kept within the family. They use strict settlement to keep land within the family through successive generations, from one generation to another. That's what they use strict settlement to do, to keep it within the family. And then it will continue to provide interest for beneficiary in that land, and then provide them with income. Now, example of how they have, they say that they have adopted or kind of adapted the doctrine of estate to achieve the purpose of strict settlement. And then in using the language of the concept of estate to draft strict settlement, an example is given to us here that, for instance, a man may execute a deed of settlement limiting the land, a deed of settlement limiting the land to himself for life, and then to Ben for life, and to the first and every other person, to Ben and every other son of Ben successively entail. When a language like this is used, they have adapted the doctrine of estate to create strict settlement, and the effect of that is that there will be a resettlement. There will be a resettlement of that land effected in each generation. Resettlement of the land effected in each generation. Then the land will be held by a succession of limited owners. It will lead to land being held by a succession of what? Limited owners. If a language like this is used to create a settlement, if a language like this is used in doctrine of estate to create settlement, what will eventually happen is that it will be a resettlement in each generation, and then the land will be held by a successive, the land will be held by a succession of limited owners from one generation to another. They will be holding it in limited, in limited form. The ownership will be limited, and therefore none of them could claim ownership of the fee simple. None of them will be able to claim any form of ownership of fee simple, with the fact that the land remained, practically inalienable. However, this arrangement has disadvantage of impoverishing the land-owning families. It will impoverish the land-owning families because there might be no fund to improve or repair the land. There might be no fund to improve or repair the land, which could have been, made possible through some form of alienation. Remember, we said strict settlement before Settled Land Act of 1882 made it impossible for you to alienate the land and keep the land in the family, such that there will be succession of limited owners from one generation to another. There will be a resettlement such that nobody can claim ownership of fee simple, and therefore it will be impossible for him to alienate. So what now happens is that because it is impossible to alienate by virtue of the rules around doctrine of estate that have been adapted to create strict settlement, then it says that it will improve, this condition impoverish the family members, and that the reason for this is that they probably will not have funds to do what? To repair the land, and then this could also have been, which could have been made possible if there was a alienation. Now, in 1882, statutory intervention, by way of Settled Land Act of that year, became so necessary to modify the practice of strict settlement. And then what happened was that the act made the settled land alienable by, empowering the tenant for life to sell. The tenant for life can now sell, he can now lease, he can now mortgage. So now what settled land has now done by virtue of section 3 is to make it possible for him to sell. Section 6 makes it possible for the tenant for life to lease. Section 18 makes it possible for tenant for life to mortgage. Now, the power of dealing with the act is vested in the tenant. The power of dealing with the land is vested in the tenant for life. It's the tenant for life that will be able to deal with the land that is so settled. Furthermore, the act facilitates dealing on such land, wherever disposition of land is obstructed by some impediments affecting its title. Example is where a conveyance, the other example I mentioned is that I said that the act makes it possible for the tenant for land to be the one to deal with the land, and also it facilitates dealing on such land wherever the disposition of the land is obstructed by some impediment. Where the disposition of the land is obstructed by some impediment, which will affect its title, the settled land that make it possible to deal with that land. And I will cite example of this last point that I mentioned to you. That, for example, a conveyance which purports to grant a fee simple absolute to an infant cannot take effect according to its terms because an infant is incapable of holding a legal estate in land. But the act construes such conveyance as an agreement by the grantor to execute a settlement by means of vesting the deed in favor of the trustee and the trust instrument in favor of the infant. So what I'm trying to say in essence is that it now makes it possible, the act makes it possible for the tenant for life to deal with the property, to alienate, to sell, to lease, and to mortgage, and also makes it possible, to deal with such land, where the disposition of the land is obstructed by some impediment affecting its title. So if the title of the land is affected by the fact that the land is conferred on an infant, it will be made possible to transact dealings, to deal with that land under this concept by ensuring that that man who is the grantor will be expected to create, a trust in favor of that disposition, or in favor of that grant that he has made, who would, more or less administer that thing in favor of the infant. So I repeat myself, example of where the act facilitates dealings on such land, wherever the disposition of the land is obstructed by some impediment affecting title, is where, for example, a conveyance which purports to grant a fee simple absolute to an infant, cannot take effect according to its terms because an infant is incapable of holding a legal estate in land. But the act, construes such conveyance as an agreement by the grantor to execute a settlement by means of vesting deed in favor of the trustees, and then the trust instrument in favor of the infant. So what this one is saying is that Settled Land Act makes it possible for you to deal with the land, even though the interest created therein is in favor of an infant who's incapable of having a title in land. And then what it does is that it will be deemed that the grantor is under the agreement to convey a kind of trust in favor of the infant, and then convey the land to a trustee who hold it and exercise power on behalf of that infant. Those are the two major how do I put it? Two major two major those are two major improvements brought about by Settled Land Act. Those are two major improvements brought about by Settled Land Act. So now let us look at how to create strict settlement. I have told you an example of how to create strict settlement. And then from these last two sentences that I make, you can see that the way strict settlement can be created is just that where Ahmed kind of execute a deed of settlement, limited land to himself for life, and to Ben for life, and to the first and every son of Ben, successively in entail. That example is a way by which strict settlement can be created. It's one of the ways by which strict settlement can be created. The second one is when we say that, the act also facilitates dealing on such land whenever the disposition of land is obstructed by some impediment affecting its title. Where we started the case of title that is supposed to reside in an infant, where the grantor will be held to be under the agreement to convey that into trustees and create a trust in favor of an infant. So I come to means of how to create strict settlement, and I've cited to you that those are the two examples of how strict settlement can be created, and that under the Settled Land Act, strict settlement can be created in two ways. One, where any interest in land stand for the time being, where any interest in land stand for the time being, limited or in trust for anybody by way of succession. So wherever you find any interest in land standing for the time being, so limited to and in trust for anybody or any person by way of succession, then you have created strict settlement. So for example, an example of this statement made is that, for example, where Ahmed, a landowner, executes a deed of settlement, limiting the land to himself for life and to Ben for life, and then to the first and every son, to the first and every other son of Ben, in such circumstances, what has happened is that interest in land stands for the time being, limited to and in trust for any person by way of succession. That's one way by which you can create strict settlement, limiting land to and in trust for some persons by way of succession. When you limit land to and in trust for a number of persons or for persons by way of succession, then what you have done is to create strict settlement. An example of that scenario is where, for example, Ahmed, a landowner, executed a deed of settlement, limiting land to himself for life, and then to Ben for life, and then to first and every son of Ben. By so doing, you have created, a strict settlement which is intended to make land, to be limited to and then to be in trust for persons by way of succession. The effect is that there will be resettlement, in each generation of that land. There will be resettlement of that land in each generation, and then land will be held in succession of limited owners. Land will be held in succession of limited owners, none of whom will now claim ownership of the fee simple, with the fact that the land remain practically inalienable, but now subject to the provisions of Settled Land Act of 1882, particularly provisions of Section 3, Section 6, and Section 18 of the Settled Land Act. So now the second way by which, land can be, by which strict settlement can be created is where a person that is seized of land or entitled to in possession to land is an infant. Where this happens, what will happen? Where the person who is seized, the person who is seized of land or who is entitled in possession to the land is an infant. What happens is what I've explained to you, that in such instance, where a conveyance which purports to grant a fee simple absolute to an infant cannot take effect according to its term, because an infant, is incapable of holding a legal, estate in land, but the act, construe such conveyance that have been made to that infant, under which he cannot hold, as an agreement by the grantor. That conveyance that he has made is like an agreement by him that, I will execute settlement by means of vesting this deed in favor of the trustees, and then the trust instrument in favor of the infant. So if a deed has been made to vest title in land to an infant, because the infant cannot hold land, and then because it cannot hold interest in land, what will happen is that deed that the man has so created to vest interest in the infant will be deemed as an agreement by him to vest that deed in a trustee or in the trustees, and therefore the trust will have been created in favor of the infant. So those two instances are cases where we can say that strict settlement has been created. Remember, we said that it will facilitate dealing with, a land whenever the disposition of the land is obstructed by some impediment that will affect the title. Example of that is when a grant is made by a grantor in favor of an infant who is incapable of holding land or holding title under the law. By so doing, that deed that he has so made, vesting title in that infant, will be deemed as an agreement that is going to vest the title in that land in some trustees, and then that trustee will execute in favor of the infant. So the first instance of, creating strict settlement is when I said that, interest in land, is limited to or in trust for persons by way of succession. So, and I cited the example of, of Ahmed, a landowner who executes a deed of settlement, limiting land to himself for life, and then to Ben for life, and then to first and every other sons of Ben. Are we together? Successively entail. And then the second instance is what I've explained to you, that where the person seized of land or entitled to possession to land is an infant. Of course, now you need to note also that the tenant for life at any point in time is empowered by the act to manage and deal with the settled land. But where is an infant, his powers are exercisable on his behalf by the trustees of the settlement. His powers are exercisable on his behalf by the trustees of the settlement. Now, because of the need to ensure that the tenant for life does not, because of the need to ensure that the tenant for life does not prostitute his powers, the act requires that there shall be trustees of the settlement apart from the tenant for life. The act requires that there shall be trustees of the settlement so created, to whom the tenant for life shall give notice in the event of any dealing in the land by such tenant for life. So what we are trying to say is that the tenant for life is empowered to deal and then manage with the property, but if he's an infant, all his powers are exercisable on his behalf by trustees of the settlement. There's a trustee of the settlement. Now, but because of the need to ensure that tenant for life does not prostitute his powers, the act requires that there shall be trustees of the settlement that we're talking about. And then to these trustees, notice shall be given in the event of any dealing in the land by such trust for life, by such tenant for life. And when capital money.
Who's
that person? Which was Ogazaza?
Oh, sorry, sir. I didn't know I was not on mute.
Okay, it's okay. I've learned one language. What is
my
Ogazaza?
It's my boy trying to upset me.
So sorry about that. Okay. So now, am I making any point at all? Are we together?
Yes, sir.
Okay.
You're moving
Yes,
so
sir.
fast, please.
Hello?
Yes, sir. I was trying to say you're moving so fast, please.
We have to finish today. We have to finish. Exam is nearby. We have to go and read. Exam is nearby. So just follow me. We'll finish it, but just follow me. Now, so we said that the settlement must have trustees to whom notice shall be given in the event of any dealing in that land by such tenant for life. Tenant for life is one that deals with land and manages it. Notice must be given to the trustees of such, of such dealings and of such management. If there's any sale or alienation and then capital money is collected, it shall be paid, and then it shall be paid to the trustees, and they will hold it in trust for beneficiaries in accordance to the provisions of the settlement. Now, let me also tell you that in the states constituting Western region of Nigeria, Settled Land Act does not apply. It is the Property and Conveyancy Law which is applicable in those states. And then PCL has abolished the concept of strict settlement in Western region, and then has substituted, therefore, the concept of trust for sale in place of the strict settlement. Thus, where an instrument proposed to create strict settlement in Western region, it takes effect as if you have actually created, a trust for sale. It takes effect as if you have created a trust for sale. You can see provision of section 3, provision of section 34 of PCL. Provision of section 34 of PCL. Now, what are the powers of tenant for life? Now, the powers of tenant for life include that, one, under the Settled Land Act, the tenant for life is normally the competent person to alienate the settled land. It can do this in a number of ways. It can alienate the land under the Settled Land Act in a number of ways. Number one, he may sell the settled land or any part thereof at the best price that can be reasonably obtained. He may do what? He may sell the settled land or any part thereof at the best price, that can reasonably be obtained. Of course, you can see section 3 and section 4, subsection 1 of the Settled Land Act of 1882. Number two, he may by deed lease the settled land or any part thereof for a term not exceeding 99 years in case of a bidding lease. Then the tenant can also mortgage the settled land. Of course, for that one dealing with lease, you can see the provision of section 6 and then section 7.1, section 6 and the section 7.1 of the Settled Land Act. Now, you also can mortgage the settled land for money or for equality of exchange, and you can even partition. So these are the points that you need to bear in mind about the powers that are granted to life tenant, so tenant for life under the doctrine of strict settlement. Of course, consequent upon the alienation, creating an interest in favor of a third party. Consequent upon the proper alienation, creating an interest in favor of a third party, the interest of the beneficiaries under the land, under this strict settlement, will become overreached, and then it will be extinguished, and immediately it will be converted to money. Now, I said, if you exercise any of those powers relating to alienation, particularly sale, it then means that the beneficiaries, interest in land will become overreached, and then will be extinguished, and then it will be converted to money. However, a tenant for life, is expected to show utmost good faith. In his dealings, so that where is found to have acted for the sole benefit of himself, the transaction in question can be shut down by the court. Of course, you can see the case of Williams and Glyn's Bank and then Boland. Williams and Glyn's Bank against Boland. Now, in the same token, any transaction tainted with fraud, such as where the tenant for life received a bribe from the other contracting party, that transaction will be set aside by the court. You can see the case of Chandler and then Bradley. Chandler and Bradley. See Chandler and Bradley. Also, now there's what there's the second aspect of settlement that we refer to as trust for sale. Trust for sale is otherwise known as a trader's settlement. It's otherwise known as trader's settlement. Trader's settlement. Now, trust for sale is created where land is conveyed, or devised to trustees with an imperative direction, to effect sale. Imperative what? Direction to effect sale. With imperative direction to effect sale. When he has the imperative direction to effect sale, now, and then he will now hold the proceed for the benefit of the desired persons or the objects. So trust for sale is known as a trader's settlement, and it is created where land is conveyed or devised to trustees with an imperative direction to effect sales and then to hold the proceed of the sales of the land, of the sale of the land, for the benefit of desired persons or the object of the trust for sale. Of course, by this method of settlement, as opposed to strict settlement, which wants to keep the land within the family. Now, by this method of settlement, what happens is that land is converted into money. Land is immediately converted into money upon the execution of that deed or will, so that, to the effect that even where the sale has not actually been effected, what we're trying to say is that the man has executed a trust for sale, saying that it's an imperative directive to effect sales and then hold the proceed for the benefit of the desired persons. They are saying that in this kind of method of settlement, land is immediately converted to money upon the execution of that deed that is giving that instruction to sell the land. And that even when the land has not been sold, what is important is that that land has immediately been converted to money from the date of the execution of that deed that is giving instruction or that is creating trust for sale. Of course, this is because equity looks, on that as done, which ought to have been done. It looks at so the doctrine of equity, by virtue of conversion, is saying that as soon as that trust has been created, and it is trust for sale, giving imperative directive to sell land and then keep the proceeds for the benefit of some people, that land is no longer land. That land is money, as opposed to strict settlement that wants to keep the land within the family. So normally, beneficiaries enjoy pecuniary interest under a trust for sale. So, but please know that it is possible for the beneficiary to have an interest in land. To have an interest in land. The subject matter of the trust for sale, as propounded in the case of Saunders, and then Vautiers. Saunders and Vautiers. In Saunders and Vautiers, what we have there, I'm coming, 1 minute. Saunders and Vautier is Vautier. Saunders is spelled S-A-U-N-D-E-R-S against Vautier. Vautier is spelled V-A-U-T-I-E, where it was held that the beneficiary with the concurrence of other beneficiaries under a trust for sale can call upon the trustees to transfer the land to him, and thereby determines the trust with the fact that the transferee acquires interest in land. So what I'm trying to say in essence is that we say that these traders, what do you call it? Traders settlement. This traders settlement that we're talking about is such that they expect you. It is expected that imperative instruction is given to the trustees to sell the land and hold the proceeds for the benefit of the beneficiaries. However, they are saying that trust for sale, which is more or less saying that as soon as the deed giving that trust for sale is signed, then there is a conversion of that land to money by virtue of the doctrine of conversion under principle of equity and trust, meaning that the interest of the beneficiary in that land is not land, but it is money. It is pecuniary, and that what they are saying is that even though the interest of the beneficiary in that land is money by virtue of conversion, and that by virtue of the nature of the trust for sale, it is money, it is pecuniary. You can still make your interest in that land to be what? You can make your interest to be land, the subject matter itself. And that is the position in Votis, in Sanders and Votis. Now, where it was held that a beneficiary, with the concurrence of other beneficiaries under a trust, can call upon trustees to transfer the land to him, and that thereby determines the trust with the fact that transferee, acquires interest in it. So if myself and two other persons are beneficiary under trust for sale, our interest is pecuniary. Our interest is pecuniary. Our interest is more or less in the money. The money that we have interest in has been created immediately that deed has been signed, even though they have not sold the land. Now, what we are not saying is that we can insist that our interest is not money, but our interest is land. And then a beneficiary with the concurrence of other people who are adults, if they are all adults, they can say that, oh, transfer this land to Dr. Idris Odekunle, and then Odekunle will become the interest holder in that land, even though the essence of a trader's settlement is that it would keep money for the beneficiaries. Now, how can the statutory trust for sale, how can it arise? Statutory trust for sale under the PCL can arise from the following ways. One, where a land, where you create a strict settlement in PCL, it will be converted to trust for sale. Where you create a strict, where a strict settlement is created in PCL state, it will be converted to to trust for sale. So where a land was subject to strict settlement before the commencement of the PCL, the instrument, embodying the instrument, the instrument embodying the settlement shall take effect only as a trust for sale. That is number one. Now, number two, when there's a conveyance or device to an infant, of course, where land is conveyed or devised to an infant, of course, the instruments operate as a declaration that the legal estate is vested in the grantor upon a trust to convey same to the trustee for sale, for the beneficiary, for the benefit of the infant. So what I'm trying to say is that if a land is given to an infant, that land is said to have been given to a trustee who will hold it on trust for sale for the benefit of the infant. If a strict settlement is created before the commencement of PCL, that strict settlement so created will be converted by virtue of statute into trust for sale. Now, tenancy in common too, a creation of tenancy in common by conveyance of deed, best legal estate in at least, legal estate in about 4 or more of them. If that so happens, what will have in effect is that your tenancy in common will be converted to trust for sale. Also, any joint tenancy that is held, who's more or less also converted to, trust for sale in PCL state. So, 4 instances can lead to having, trust for sale. One, when a strict settlement is being created before the commencement of PCL, such strict settlement will become what? Will become, trust for sale. If a conveyance is also made to an infant who is incapable of holding interest or title in land, it will become, trust for sale. Also, tenancy in common will be converted to trust for sale. Joint tenancy will also be converted to trust for sale. So now, what I wanted to do, I have been able to achieve it, but I want to go back In the event that we cannot finish, what I decided to do was to give you a gist of the doctrine of settlement. So, for those of you that you still want to, have expanded knowledge of what we are talking about, I'm going to go back to, elaborate discussion. But in the event that we cannot finish everything that you need to know about, what's it called? About this doctrine of settlement is what I've mentioned to you. However, let me before I go back to elaborate discussion, there are some differences that exist between the two of them that we need to note. Are we together? The first one is that the object of strict settlement is to retain the land within the family of the settlor, as long as possible. That of trust for sale is that the land should ultimately be alienated. That's one difference between the two of them. The second one is that the subject matter of strict settlement is land and remains so until settlement is determined. Of course, the subject of trust for sale is money and then personality. This is so because the land originally, of course, the land originally, how do I put it? Because the land, which is the subject matter, is by doctrine of conversion, in equity, deemed to be money upon the mere execution of the enabling instrument. So now subject matter in strict settlement is land. Here it is money, even though it has not been converted, even though it has not been sold. Upon execution of that instrument, that land becomes money. Here, land is to be kept in the family in strict settlement, whereas in the case of trust for sale is to be alienated. Now, Section 38 of PCL also says that also vests in the trustee for sale, alone, who can deal with the subject matter and not the beneficiary until sale. Whereas under the strict settlement, of course, tenant for life is empowered to deal with the settled land, as the trustee for sale. So what I'm trying to say in essence is that there are some distinctions that exist between the two of them. One, here, the intent in strict settlement is to keep land within the family, whereas in trust for sale, it is to alienate the land. The subject of the transactions in a strict settlement is land, whereas the subject is money in a trust for sale. And remember that Section 38 says that it is the trustee for sale that can deal with the matter, not the beneficiary that can deal with the land. It's not the beneficiary. Whereas under the strict settlement, it is the tenant for life who is the beneficiary that is capable of dealing with the land. Now, also note that the original conception of trust for sale is alienation of land. Of course, with the proceed held in trust for the beneficiaries. However, there are a number of circumstances that remain, that could restrain or make it impossible for the trustees to sell. There are circumstances that make it impossible for the trustees to sell. One of them is that there must be, unanimous agreement. There must be a unanimous agreement. One of them is that there must be a unanimous agreement. There must be a unanimous agreement among the trustees before the power of sale, can be exercised. Otherwise, transaction will be void and it will become a nullity. So one of the things that hindered the exercise of powers under the trust for sale is that there must be unanimity among there must be unanimous agreement to exercise that power of sale. Otherwise, transaction will be a nullity. Now, they say that where there is no unanimity, among those who are by law required to consent to the sale, then the sale cannot be effected. And in fact, the land remains in the settlor's family. So what I'm trying to say is that one of the hindrance, one of the limitations to the exercise or the operations of trust for sale is the fact that there must be unanimous agreement in exercising the power of sale by those people upon whom the power has been conferred, and that if that power is exercised without that unanimity, it could be a nullity. And that when they are unable to agree, it then means that power of trust for sale may not be exercisable, and then the land will remain in the settlers' family. Another example is that where a person of full age, note very importantly, number 2 hindrance to exercise of power of trust for sale is that where a person of full age, is in possession of the land, they are, persons of full age in possession of the land are more or less beneficially interested. If they are beneficially interested in the rents and profits of the said land until sale, they must be consulted by the trustees. And so as far as it is contained in the general interest of the trust, give effect to the wishes of such persons. So if those persons in possession, are more or less interested in rents, and that is, if the beneficiaries are more or less interested in rents and profit, arising from that land until sale, they must be consulted before the trustees would sell. Are we together? And then they must give effect to the wishes of such persons. Dispute between trustees and such persons could frustrate the sale of the land, and then as court action may actually may be resorted to by the parties, and then another, may give effect to, wishes of the parties, and then courts may make such, others as they may think fit. So what I'm trying to say is that one, power to sell under trust for sale is such that must be exercised in unanimous agreement. Number 2, the persons who are beneficiaries who are in possession, who are more interested in rent and profit before the sale, their interests must be taken care of by the trustees for sale, and then they must be consulted, and then they cannot exercise that power against the wishes of those people. And this may lead to court action where there's a disagreement, and then of course the court may end up granting an order that would more or less reflect the wishes of those adults, full adults who are in possession, who are more beneficially interested in the rent and profit. The third one is that a trust is created where a trust is created for a particular purpose, or for a collateral purpose, and that collateral purpose is still subsisting. Court will not exercise its discretionary power in favor of the sale. Now, but if the trust has been exhausted, if the trust has been fulfilled and no longer subsists, an order for sale may be made by the court. So those are the constraints that trust for sale may actually have. One, there must be unanimous. Hello? The constraints that trust for sale may encounter include that there must be unanimous agreement in the exercise of power for sale. Number 2, the persons of full age who are in possession, who are beneficially interested in rent and profits of the land, until sale, must be consulted by the trustees before the power of sale is exercised. And if they feel otherwise, the court may grant an order to reflect the intentions and wishes of those people. Then again, if a trust is created for a collateral purpose, which is still subsisting, and then the court may not exercise its discretionary power to grant an order for sale of that same property, unless that trust has been fulfilled, or unless the trust no longer subsists, or otherwise. So now I wanted to give you a more I want to give an elaborate more explanation about what I've said. So I'll go back to the beginning. That as it may, please note this. Please note this summary that I've given you. They are very important for you to understand the concept of settlement. So now I go back to my explanation, and I say that a landowner. So because if you don't have time again, then I have done what I need to do. I'm just trying to elaborate on what I have taught you and what I need to teach you. So now, for the remaining 30 minutes, and then we'll begin to explain what I have. I would explain in a how do I put it? In a larger form. in an expansive form, what I've actually explained to you. So now when we talk about the concept of settlement, now we are saying that a landowner who desire to provide for a succession of beneficiaries out of his property or income accruing there may adopt a modern method of settlement. There are two methods of settlement. Is this person? There are two methods of settlement. One of them is strict settlement. The other one is strict settlement. The other one is trust for sale. The method to be adopted, like I mentioned to you, would depend on the intention of the landowner, the object of the settlement, and the requirement of the law that is applicable. Now, if you talk about strict settlement, before the Settled Land Act of 1882, the conception of strict settlement was a reflection of the English social life for many centuries. The Settled Land, before the Settled Land Act of 1882, the conception of strict settlement was a reflection of English social life for many centuries. Of course, the feudal system in England at the time, of course, brought about the idea of keeping land, within the family, through successive generations. It was feudal system that brought about the idea of keeping land in the family through successive generations. And therefore, the English doctrine of estate was adapted. The English doctrine of estate was adapted to achieve this purpose. And for example, like I mentioned to you, A might execute a deed of settlement by limiting the land to himself for life, and then to B for life, and then to the first and every son of B successively entailed. Of course, this will ensure that the land is kept within the family. Nobody will have what is it called? Nobody will have absolute ownership. Nobody would have more than life interest in the property, and then the property will be kept within the family. Of course, this will ensure that land remains the family for a number of generations, and with settlement affected in each generation, the land was held by a succession of limited owners, and then none of them who claim to be the owner of fee simple. None of the owners of such limited interest could outlast his life interest. He cannot outlast his lifetime, nor can he mortgage or charge the land for loan. Of course, when we're talking about strict settlement, in the manner that we have explained above, it will afford the landowner a convenient means of providing for his descendants by ensuring that the land was kept within the family and remained practically inalienable, and it had the particular disadvantage of impoverishing families, as there will be no sufficient fund to maintain the land by raising money for its improvement or repair through sale, mortgage, lease, or charge. Of course, it was not possible for the tenant for life unless the settlement itself gave the express power to the trustee to sell the settled land for any greater estate than he has possessed himself. Nor could he grant leases for a period longer than his own lifetime or his own life. So now the Settled Land Act, like I mentioned to you, plays a dual role. The first one is that it makes settled land alienable by giving tenant for life the statutory powers to sell, to lease, to mortgage. And secondly, it facilitated the dealings where, wherever the disposition of the land is retarded or obstructed by any impediment that is affecting title. Of course, we cited example in this case of a conveyance which proposed to grant a fee simple absolute to an infant, which cannot take effect according to its term because an infant is incapable of holding a legal estate in land. Of course, the Settled Land Act has construed such conveyance, as an agreement by the grantor to do what? To execute a settlement by way of vesting deed in favor of trustees, and then the trust instrument in favor of the infant. Remember that we mentioned that 2 ways by which you can create strict settlement is 1, where estate or interest in land stand for the time being limited to or in trust for any person by way of succession. An example is what you started above. A, as a landowner, execute a deed of settlement limiting the land to himself for life, and then to Y for life, and then to the first and every son, of Y successively until a strict settlement will be created. And secondly, where a person who is in his own right is seized of and is entitled in possession to the land, is an infant. The land is settled land and remains so, whether or not it is held in trust for the infant jointly with adult beneficiary. So now, the point I'm trying to let you know is that now the powers of dealing with the settled land is vested in tenant for life. And a tenant for life has been described to include any person whose estate or interest takes effect in possession, and then it could include, tenant entail, tenant in principle with an existing limitation. So if your principle is having an existing limitation, then you are more or less, creating, a strict settlement. If you are a tenant for years, that is determinable under this law, you are a tenant for life. If you are a tenant, you are a tenant whose own life, is a tenant for your own life or for another person's life, you are a tenant for life. If you are a tenant by courtesy, you are a tenant under this doctrine of settled land that we're talking about. Now, settled land that vests the tenant, for life, such powers of management and dealing with the land, and then remember that where the tenant for life is an infant, the power will be exercisable by the trustee of the settlement. I also mentioned that the power that we're talking about, whether it is given by the settlement or by statute, is void unless the condition imposed by the instrument or statute from which it rests were observed. You must observe the instrument creating the instrument creating the strict settlement and the statute. Of course, to ensure that tenant for life does not misuse its power, the Settlement Act also requires that there shall be trustees of the settlement to whom notice shall be given in the event of any dealing in the land and by that tenant for life, and then to whom capital money should be paid, and they held in trust for the beneficiaries in accordance with provisions of the settlement. Of course, where the settlement does not provide for such trustees, or where it is expedient, where the settlement does not provide for such trustees to whom the tenant for life will give notice and pay the capital money to. But it is also becoming expedient that we have one. One may be appointed by the court, and then, to that extent, I also mentioned to you that before any statutory power is exercisable, it is essential that within the meaning of the act, the instrument creating the power, the instrument creating the power is the settlement, and the donor of the power is the tenant for life, or one of those persons to whom statutory power has been given, that that the trust is properly constituted. So what I'm trying to say in essence is that the definition of who is a tenant has been given to us to include those persons like tenant for years determinable, tenant for his own life or the life of another, a tenant by courtesy, somebody who is entailed with existing limitations, and then so on and so forth. We also mentioned that the Settled Land Act makes it possible for the tenant for life to deal with it and give notice to trustees and so on and so forth. And then we're not talking about application of a Settled Land Act. One, it gives the tenant for life to do what? To sell. Now, tenant for life can sell, like I mentioned to you, it can sell the settled land or any part of it, or any of the instrument that's attached to it, any right or privilege of any kind over and in relation to the same land. Also, he may also exchange the settled land or any part of it or other land, including an exchange in consideration of money. So what we're trying to say in essence is that he could sell, he could exchange land, any part of it, for consideration and equality of exchange. So please note also that for every sale, every sale shall be made at the best price, that can reasonably be obtained. Are we together? Apart from the fact that he could sell, he could exchange the land, he could also partition the land. Please note all of that in mind, bear them in mind. He could sell, he could exchange the land for another, he could partition the land. Then any sale that is made, must be at the best price that can reasonably be obtained. While every exchange and every partition, every exchange, every partition shall be made for the best consideration. Every exchange, every partition shall be made for the best consideration in money that can reasonably be also obtained. A sale may be made in one lot or in several lots, and either by auction or by private auction. Of course, on a sale, tenant for life may fix a reserved biddings. Of course, a sale or exchange or partition may also be subject to any stipulation, respecting title and rest of that. Of course, tenant for life may decide to sell when he pleases and pass a good title to a purchaser, whatever the motive, it doesn't matter, provided that he says, at the best price reasonably possible or reasonably obtainable and satisfy the statutory requirements. Are we together? Now, they are even saying that even if he breaches the statutory provisions in relation to the transaction, the title of the purchaser, who acted the title of purchaser, who paid title of a bona fide purchaser for value, who acted in good faith, is also protected against all parties, who are entitled already. So they said that even when he breaches, when the tenant for life breaches the statutory provision, when he's making the sale, and then there's an irregularity in the power that is exercising, the bona fide purchaser for value, who bought in good faith, his title will be protected. Now, let me also come to power to lease. Remember, he has the power to lease. Part of his power includes the fact that, he may lease the settled land or any part thereof for any time that is not exceeding 99 years in the case of a building lease. Now, he can lease for 60 years when it's a mining lease. He can do 21 years in the case of other leases. Every lease which he shall enter into shall be by deed. He shall enter into lease by deed, and then will be made to take effect not later than 12 months after its date of the execution. So it can make lease provided that it is by deed, and then the date of taking effect of that lease must not be later than 12 months after the date of execution. And it shall receive the best rent that can reasonably be obtained, and shall also contain a covenant. It shall contain a covenant by the lessee for payment of the rent, and a condition for re-entry on the rent being paid within a time therein specified, not exceeding 30 days. So it's saying that there must be lease made not exceeding 99 years for bidding lease. You could make lease not exceeding 99 years for bidding lease, 60 years for mining lease, 21 years for any other lease. And that it is said that when he makes the lease, it shall be by deed, and then, of course, it shall take effect not later than 12 months thereafter. And then, of course, shall be the best rent that is reasonably obtainable, and that it shall contain a covenant that the lessee shall pay for the rent, and that there is a condition for re-entry in the case that the tenant failed to pay, and then payment must not exceed 30 days from the date of execution of the will. Of course, the counterpart of the lease shall be executed by the lessee, and then delivered to the tenant for life. And the execution of the lease, execution of lease by the tenant for life shall be sufficient evidence of such lease. Also, a statement that is contained, if any statement is contained in that lease, or any endorsement thereon, signed by the tenant for life, respecting any matter of fact or calculation under the Act in relation to the lease, shall in favor of the lessee, and those claiming under him be sufficient of that matter. So anything that is stated in that thing shall be in, whether it's of any matter of fact or calculation, shall be in favor of that lessee or anybody claiming through him a sufficient evidence of that matter so stated. Of course, counterpart shall also be executed by the lessee. Of course, they say that when it's granting this lease, when the tenant for life is granting this lease, of course, they are saying that he has power to enter into any list that will flow from the contract that his predecessor entitled has actually entered into. If his predecessor entitled had actually granted any form of renewal covenant, he has the power to allow that renewal to take place. And also, they are saying that if any list that have been, if any list in the past that have been executed by his predecessor entitled, if it's void or voidable, he has power to confirm that list and then make them to be valid by this new list that is signing. So he has power to make valid void or voidable lists that have been signed by the predecessor entitled. He has power to accept renewal in respect of a list which has been created by his predecessor entitled. He has the power to do what? To enter into a list by virtue of any contract that has been entered into by his predecessor entitled. Of course, a tenant for life may also, mortgage the property, and that is by provision of section 18 of the Settled Land Act. Of course, note also that upon the sale, please note upon the sale, the exchange, partition, lease, mortgage, or charge of the settled land, the tenant for life shall convey or create, this by what? By deed. And such a deed is effectual to pass the land conveyed, the easement, rights, privileges so created, and discharge, from limitations, powers and provisions of settlement from all equivalencies subsisting or arising therefrom. So that upon what they're trying to say here is that as soon as the deed has been made to convey the land to a third party, when deed has been made to convey the land to a third party, now what now happens is that the interest of the beneficiaries in the land under this settlement will become overreached. It will be destroyed. It will become overreached and become destroyed, and it will immediately be converted to money. To be immediately be converted to money. Now, when we are talking about, what is it called? When we're talking about, strict settlement, there's some limitations you cannot put on the power of tenant. There's some limitations you can't put on the power of. There's some limitations that you cannot put on the power of tenant for life. Now, any instrument that is purporting to prohibit or limit any of the statutory powers of tenant for life in any manner, or to indicate him, or to induce him to abstain from exercising such power is void. I repeat myself, there are some limitations that you cannot put on the, on the power, on the tenant for life when he's exercising his power. One, any instrument that is purporting to prohibit or limit any of the statutory powers of the tenant for life in any manner, or that will induce him to abstain from exercising that power, will be void. Are we together? Are we together? Are we together?
Yes, sir.
Are we there? Are we there?
Yes, sir. Yes, sir.
Yes, sir.
Okay, so I'm just elaborating. I have given you the basic things that you need to know about strict settlement and trust for sale. So I'm just elaborating on it. So now we also say that a tenant for life, being a trustee of his power, any transaction negotiated by him for the sole benefit of himself or his relative, may be set aside. I think I've said this one before. It's just a repetition. So any power of tenant for life cannot be assigned or do not pass to assignee, but remain exercisable only by the tenant for life, notwithstanding any purported assignment of any sort. So I'm talking about prohibition and limitations on the powers of trust of tenant for life here. If there is any instrument that is prohibiting or limiting any statutory power that is given to the tenant for life, or that is inducing him not to exercise such power, that provision will be void. Of course, I also mentioned to you that now, if a tenant for life is exercising his power, he cannot do it in a way that it will amount to fraud. it cannot do it in a way that it will amount to exercising that power to favor himself alone. Now, also, we said that his power cannot be assigned to anybody. The power remains exercisable by him alone. If there's any instrument that he has exercised saying that I'm assigning my power or my right to you, that thing is not possible. It's impossible. Now, I have also mentioned to you some of the things that we need to know about strict settlement. Remember that we said that I have explained to you that it's known as a trader's settlement, and that traditionally what it means is that when there's a strict settlement, I am tired. Can we do this? Okay. Do you still need me to come back on Thursday to elaborate on the trust for sale? Hello? Hello? Hello?
Yes, sir.
You still want me to come on Thursday? Do people want to come on Thursday? I want us to finish it now.
I
can Hello?
come on Thursday.
Come back on Thursday.
On Thursday. Okay. Okay.
Yes, sir.
Okay, let's call it a day today. Then we
Let's
can
finish it now, sir.
Okay, we can finish. So I have even told you what you need to know about trust for sale. Trust for sale, like I mentioned to you, is known as a trader's settlement, and it's created whereby land is divided to trustees with an imperative direction to do what? To effect sale and hold the proceeds, for the benefit of the beneficiaries. Now, remember that as soon as that deed is executed by doctrine of conversion, the interest in that land is no longer the land, is money. And then because equity, is by its doctrine saying that equity looks on that as done, which ought to have been done. And then, of course, the imperative direction is to turn, the land to money. But I'm saying that this right that says that, when trust for sale is created, it is more or less saying that there's a converting land to money. You can retain the land. You can retain the land if you decide to do so. And if you're adult and then you are consenting. And that's the case of Saunders and Vautiers. Saunders and Vautiers have explained to you that if one of the beneficiaries, with the consent of all other adult beneficiaries, will say that the trustees should transfer the land to him, even though there's a trust for sale, the trustees will have to do so, and then the trust will terminate. Of course, the interest in land, the interest in a concept of in a trust for sale is what is the money, not the land. But you can turn the interest in that trust for sale to land by virtue of Saunders and Vautiers, of course. So what we are trying to say in essence is that when can you have strict settlement? I have mentioned when can you have trust for sale? One, when you do what? When there was a strict settlement that was created before now. Two, that is before PCL, that thing will be converted to what is called it will be converted to trust for sale. Two, when you convey land and devise it to an infant, it will be what? It will be trust for sale. It will be trust for sale. Are we together? When there is tenancy in common, it will be trust for sale. It will be trust for sale. When there is a joint tenancy, it will also be what? It will also be trust for sale. Those are the circumstances by which we can create trust for sale. Now, when we talk about the powers, of trust for sale, remember that I mentioned that there are some distinctions, there are some limitations that can hinder the exercise of that power. And one of them is that there must be unanimous agreement to exercise the power of sale. Otherwise, the sale will not be valid. Okay. Number two, I also mentioned that where persons of full age in possession are beneficially, interested in the rent and the profit of the land until sale, you must sell with the consent of those people. Because if they disagree with you, they can go to court and they will get an order to more or less, entrench their interest. Number three is also that, where trust is created for a particular collateral purpose, which is still subsisting, court will not exercise a discretionary power in favor of trust for sale. But where the trust, has no collateral purpose, or its purpose has been fulfilled or no longer subsists, a sale will be ordered. I also mentioned to you that there are some, distinction between strict settlement and trust for sale, which is that one, the object of strict settlement is to tie up the land within the family, of the settlor for as long as possible. And that of trust for sale is that land should ultimately be sold out of the family. Now, the second is that subject matter of strict settlement is land, and they remain so until settlement is brought to an end. But the subject matter of trust for sale is personality and the money. And that this is so even where land was the original subject matter, because, according to the equitable doctrine of conversion, land held on trust for sale is regarded as money from the moment the trust for sale is constituted, since equity looks upon that as done, which ought to have been done. Then I also mentioned to you that section 38 of PCL, says that, legal estate vested in trustees for sale, who alone can deal with the subject matter and then not the persons. So what I'm trying to say in essence is that the subject matter is vested in trustees. They are the only one that can deal with the matter under, when we talk about trust for sale, it's the trustees that can deal with it. Whereas under the strict settlement, it is the tenant for life that can deal with it. So that is in essence the whole idea of strict settlement and trust for sale. Now, I need to let you know that the concept of strict settlement is relevant in construing those wills and deeds that are creating those settlements before the Land Use Act. So the Land Use Act did not operate retrospectively. It operated from 1978. So any settled land that was created before 1978 will be is not tampered with by Land Use Act. It's not tampered with by Land Use Act. But subsequent to that, it is going to be operating subject to the provisions of Land Use Act. So, ladies and gentlemen, I will meet you in the exam, and I wish you best of luck. Go and prepare and read very well. We have done 2 topics together, and then one is doctrine of estate. Number 2 is doctrine of strict settlement, and then trust for sale. Trust for sale is applicable in Western region, while the strict settlement is applicable in other parts of Nigeria. And then remember the powers of tenant for life. Remember what he needs to do. Remember that there are trustees created under it. Remember the amendment made by Settled Land Act. Remember the distinction between them. Remember the problems and the limitations that would militate against the exercise of powers by trustees under the trust for sale. So remember that another name for strict set for trust for sale is known as a traders settlement. Settlement. Remember that tenant for life is the only one that can exercise his own power. Is the one that is given right to deal with the land. Is the one that has power under a settled land and to mortgage, to lease, and to do rest, but only to give notice and then pay the capital money, give notice of dealings, and pay capital money to what's it called, to the trustees. So on that note, I wish you best of luck. And then we have come to the end of first semester.
Sir, are we reading this part for test?
For what? For test. Hello? For test.
Yes, sir.
I'm going to read everything. Everything. Hello, Alaji.
I can't hear you again, sir.
Alaji.
We can't hear you.
Sorry, guys. I'm so sorry, please. The call interrupted me. The call interrupted me. I was trying to tell you, go and read everything now. It's everything that you have to read. It's good for you to know everything. What is it that, for this one I have taught you now, what is difficult about it? They said there is settlement, strict settlement or trust for sale. Strict settlement says that tenant for life can deal with it. You can grant leases, you can grant this, you can do mortgage, you can sell, you can alienate, you can when it sells, that means that their interest is overreached. Then the trust settlement is the settlement is overreached, and then it's terminated. You know, the essence is to keep the land in the family, and then nobody will have, power to sell. And then the conception is adapted from the doctrine, is by adapting the doctrine of estate to suit it. It could arise when a grant is made to an infant. It could arise when somebody is trying to keep the land within the family by creating successive beneficiaries. He could do all of those things that we have mentioned. So, you know, he must get the appropriate rent. He must make sure that the lease is by deed. He must make sure that it takes 12 months after it has been signed. He must make sure that there's a clause for re-entry. You know, you cannot tell him not to exercise all of those powers. Anything compelling him not to exercise it is more or less will be void. Strict settlement, trader settlement can arise where there's joint tenancy, where there's tenancy in common, where there's where anyone has been created in this PCL state before the coming to effect of PCL. Are we together? You know, remember that there is hindrance to the fact that there's unanimity in the exercise of that power when it's to be done. Remember that even though the interest in land, you know, in that interest in that object, in that instrument, is basically creating interest in land, in money. It can be, you know, it can be turned to land if it is intention of the parties that they want to retain the land. Remember all the problems, like if there are beneficiaries, owners who are in possession, or beneficiaries who are in possession, who want to be getting interest, getting profit and rent from the land. You cannot sell that power, that trust for sale without carrying them along. Remember that if there's a collateral purpose for which the trust for sale is created and then it has not been executed, it has not been fulfilled, you cannot exercise that power. Okay, so these are some of the things that you need to know that I don't think is difficult. If you get home and then you sit down with it and you read it, it will sink. So you have to read everything. The doctrine of estate, you have to read. Joint ownership, you must read. Settlement, you also must read. And I wish you best of luck. I'm not sure that these are difficult things to do. I wish you best of luck.
Thank you, sir.
Yes, sir.
Thank you, sir.